Hello and good evening, everyone. Thank you very much for joining us tonight here at UCL Laws. And it's a great pleasure and a great honor to have Kate Bell tonight speaking to us about labour law reform in the United Kingdom at such a crucial moment for labour law and labour rights in the UK. Kate Bell, as I'm sure you all know, is the Assistant General Secretary of the Trade Union Congress, the TUC, which is the UK umbrella union organization representing 48 affiliates and nearly 6 million workers. There is no other body in the UK that has such a degree of representation in society. She joined TUC in 2016 as head of economics and employment rights. And she's actually a historian and political scientist and theorist by training, having earned degrees from other institutions, I should say.
Sorry.
Kate came to TUC after a long and diverse career path that eventually took her to the pinnacle of the British labour movement. But before, she worked for local authorities, for charities. She worked as a researcher, as political advisor, as a member of the Labour Party, and more recently as a member of the Low Pay Commission. Whilst I'm sure you know, various men have claimed paternity for the furlough scheme during the COVID pandemic. We very much owe, and I know this for a fact, to her and to her input, that for all its shortcomings, the furlough scheme was at the very least pitched at a level way above subsistence, and actually in a comparative perspective offered generous or comparatively generous levels of income replacement. And not just to standard employees. There's a clear resonance between these traits of the scheme and her work on adequate wages in recent years. Kate has been at the forefront of the debates and the discussions between the TUC and the Labour Party in respect of labour law reform for a number of years. In fact, we were trying to find an accurate date, but at least since 2016, if not before. These are the very same debates that eventually led to Labour's plan for making work pay a new deal for working people, the policy document that has now to a large extent materialized in the Employment Rights Bill that was presented in Parliament less than 2 weeks ago. This bill has already been defined, including by the TUC, but by many others, as a watershed moment in the history of labour rights in the UK. And I think this is a very appropriate characterization for this document. It's a pleasure to hear from Kate about this very important topic. You can, of course, read the bill yourselves. I'm sure some of you have. All of it's 158 pages, but hearing from Kate and hearing her views on the subject is a unique opportunity, and we thank her for that. Kate will speak for about 40 minutes, and she's very kindly accepted to take questions from the audience tonight. Thank you very much, and thank you very much to you, Kate.
Thank you so much, Nicola. Thanks for that incredibly generous introduction. That was really, really kind. I don't actually know how long I'm going to talk for, because as will become clear throughout this presentation, we are in a very fast-changing environment. So, as Nicola just said, we had the publication of the Employment Bill, as I'll go on to say, the culmination of a lot of work, I think a week and a half ago. It's nice to be in a room right now which sort of looks like Parliament, because Parliament are currently debating this bill as we speak. We'll see what the quality of the debate here and in Parliament, how that compares when we get into the questions. About 6 hours before this presentation, the government published a whole load of consultation documents on this. So there is a lot of detail and it is changing quite quickly. So what I'm going to try and do in this presentation is just kind of remind us a little bit about why this subject matters, why trade unions, why many others have been campaigning about the quality of work in the UK, and a little bit about the kind of background that got us to this bill. I'm then going to try and talk about what the employment bill does. It is absolutely massive. It's quite complicated. It has got a lot of things which are TBC, basically, where C in this case is consulted on. But I'm going to kind of outline the main provisions, kind of with an idea of giving you a sense of the size. But I'm a bit worried in that section of the talk, I'm going to be too detailed for some people and not nearly detailed enough for others. So bear with me. I'm then going to go back to sort of my background, as you said, as a history student, and just try and reflect a little bit on why is it we're here at this massive moment for kind of labour law reform? What are some of the factors that might have got us there? And I'm really interested in people's reflections. It's sort of been my first attempt writing this lecture to kind of try and reflect on why are we here? What are the factors? So it's the first go, so I'll welcome your feedback. And then I'm going to talk a little bit about what comes next. So to kick all that off, so why does this all matter? Basically, why are we here? Why has the Labour Party put this employment bill kind of front and centre of some of its programme? And here is a not very beautifully presented set of charts that kind of try to explain to you just how far the UK has fallen behind when it comes to labour protections. This comes from some work that Simon Deakin and Dr. Irakli Barbakadze did for the TUC, building on some earlier work at Cambridge. And it basically sets out the UK, that's the purple line, compared to the OECD average on a kind of index of rights that they have put together. And you can see that on everything except what they've called different forms of employment, which is around protections for part-time workers, there's this big gap between the UK and the OECD norm. A reminder that the OECD is an average that contains countries like Australia and the US, where labour protections are very weak, as well as countries like France, Germany, in some cases, Italy and Spain, and the Nordic countries where labour protections are stronger. But you can see that the UK is really an outlier when it comes to how it protects people at work. You can also see that this has real consequences on people's lives. And just for this section of the talk, I've mostly used quotes from a campaign we ran where we just asked people to write in and tell us why the employment bill was important to them. And I think just before we get into the kind of detail of the provisions, it's really important to remember what this means for people's lives in their everyday workplaces. So I'll just kind of give you some highlights of the quotes. Hopefully you can kind of read some of these, but this was from a woman who wrote to us who says, my son's just walked in from work, he's really poorly. I've said, don't go to work. He said, if I don't go to work, I don't get paid. So massive lack of decent sick pay in the UK, real impact on him. The next one is a quote from a hospitality worker. She's saying, I need this job. I'm struggling to keep up with the cost of living. The pay is low for the work you put in. It's really precarious in terms of hours and workers' rights. It's an industry dominated by very skilled workers. Hospitality, a really skilled industry, but the pay never matches and people really struggling to make ends meet. A couple more here, people talking about how 0 hours contracts, over 1 million people are on 0 hours contracts in the UK, mean that you can't budget for your food or your heating. If you go off sick, you have no chance to get back on track with your bills. Another person as a healthcare assistant talking about how she was injured at work but didn't receive any sick pay. And she's talking about the costs of fuel. And when you talk to workers in these situations, it will often be, I didn't have enough money to put petrol in the car. I wasn't sure if I was going to be able to turn the heating on. I needed to get to work, but I wasn't sure if I could afford the bus fare. One last set of these quotes. These are actually two people we talked to who were featured in the Daily Mirror this morning, so I've pulled them out because they're very contemporary. But this is a care worker talking about, I don't know what income I'm going to get each month, depending on my hours. It's difficult because I don't know what I'm going to do on a daily basis, if I want to take my daughter out or to meet my shopping or utility bills. And then here's someone talking about the impact of insecurity on their rights at work. So saying, I could get a text now from my boss saying, I want you to come in at 8 a.m. tomorrow, even though I wasn't scheduled, and then talking about that on their ability to kind of enforce their rights at work, saying, if I say no, I might not be given any hours next week. So hopefully giving you a kind of sense of picture of the insecurity, the low pay, the lack of rights across too many jobs in the UK today. A lack of collective rights, also a massive issue. These are just two, I guess, of some of the most high profile cases that trade unions have fought in recent years, but they'll be replicated in less high profile ways up and down the country in many situations. So P&O Ferries, most of you are probably aware of this case, but 800 people were sacked basically by Zoom and replaced by lower paid workers on agency contracts without really any recompense. The second one is just highlighting the organising campaign that's been taking place in an Amazon warehouse. Basically, those workers really came really close to beating the thresholds for gaining statutory recognition, which means your employer has to sit down with the union and negotiate with you. Loads of hostile anti-union tactics from the employer, not letting them on site, flooding the workplace with hostile anti-union propaganda, and those workers just missing out on getting their chance to have a fair say at work. So a bit of a gloomy picture of work in the UK, and I hope kind of explaining to you the background of why this has been such a big feature of trade unions campaigning work in the last few years. So, as Nicola said, the employment bill just published, being debated right now, is a chance to shift all of that. The Prime Minister has described it as the biggest levelling up of workers' rights in a generation. The Deputy Prime Minister, I think, echoing some kind of trade union language around ending the race to the bottom that saw some businesses compete based on low pay, low standards and insecurity. Labour lawyers Alan Bogg and Michael Ford have described it as potentially the most significant shift in union and employment law in the last 50 years. And my boss, Paul Nowak, the General Secretary of the TUC, has described it as a real moment of hope for working people. So next we get into my attempt to summarise some of what is in the bill. I'm just going to pay credit to my colleague Tim Sharp, who leads our work on this, and I have cribbed most of this work from him. And basically, I've tried to give you a reasonable summary here, and part of the aim is to show the kind of breadth of the provisions that are in the bill. But if you think I've summarised it wrong, tell me in the questions, and we can come on to it. So there are provisions to end the use of exploitative 0 hours contracts. These provisions, for anybody who has looked at them, are fiendishly complicated, but the intention, as set out in the accompanying consultation documents, is that after 12 weeks, you will be given a right that reflects the hours that you regularly worked. A lot of details still to be worked out on that, but it comes accompanied with the offer of reasonable notice of shifts and payment for a cancelled shift. So potentially a significant set of changes. As I said, a lot of detail to be worked out to make sure that these are watertight. At the moment, the bill says these do not apply for agency workers, but as I'll come on to say, a consultation has been published which says we intend to apply these to agency workers. How shall we do it? So I imagine a lot more complicated clauses to come in this area. There are also provisions on flexible working and enhancing the rights to genuine flexibility. I think it's fair to say this is an area of the bill we are a little bit disappointed in. The strengthening of the rights to flexible working is relatively weak, and there are no changes to the reasons that a business can turn down a request to flexible working. But the employer now has to explain themselves for why they've told you, no, you can't change your hours, you can't change your pattern of shifts. So potentially a step forward, but again, a long way to go on all of this. I'm just going to move, if I can, the picture so I can see my notes. There we go. Next one, I've tried to group these in kind of areas where it's vaguely thematically consistent. So this is about more money in workers' pockets fundamentally, although it could be argued that across the bill, these are rights for more money in workers' profits. So statutory sick pay, at the moment, you have to wait 3 days to qualify before you are able to access the statutory level of sick pay. It will remove those 3 days, a potentially really significant change. At the moment, you have to earn a certain amount before you qualify for sick pay, and the bill will remove that what's called the lower earnings limit, or the eligibility test linked to the lower earnings limit. And then it says we're going to consult on, if you are a low paid worker, how much are you actually going to get in that situation. So again, much more to be found out there. On tips, it slightly strengthens the requirement to consult with unions, basically, but it doesn't say that workers have the right to decide how tips are distributed. Many of you will know that if you work in hospitality, tips often form an important part of your reward for working in that industry. So this is saying that workers will get more of a say on how those tips are used. And again, it requires employers to specify what they're doing in response to workers expressing their views. Again, I'm not sure if this heading is right on better equalities protections. This isn't really kind of fully equalities, but there are some strengthening of family leave provisions, including removing qualifying periods for parental leave and paternity leave. When people talk about day one rights, this is one of the day one rights they are talking about, and I'll go on to talk about unfair dismissal. And there is a strengthening of the provision for protection from sexual harassment, extending the duty on employers to take reasonable steps to prevent third parties from sexually harassing their workers. Again, more work to do, but I think we see that as a significant step forward and one that was missing from the earlier legislation in this area. This is when we get to the other bit of day one rights. And again, one of the fiendishly complicated parts of the bill, with an awful lot still to be done. So you will probably know, or you may know, that the Labour Party promised to introduce day one rights for protection from unfair dismissal. And this is following the Conservative government doubling the period during which you had to wait before you are protected from taking an unfair dismissal case. The bill does remove that qualifying period. It strikes out that 2-year qualifying period in the law, but it says that it will have a new statutory probation period. They're calling it an initial period of employment. The length of that is to be determined, and the protections you actually get from being unfairly dismissed are also yet to be determined. They have said that it can't be because of redundancy during that period as a reason for fair dismissal, and you will still be able to claim the right to unfair dismissal. But again, that's an area of the bill where we think a lot more work is needed to be done to make sure that workers actually get the protection they need. We have got provisions in here on fire and rehire and fire and replace. Again, I think this is a step forward from what we have heard from governments before. So fire and rehire is when somebody is told, basically, we are going to fire you and we are going to rehire you on a contract which lowers your pay and lowers your terms and conditions. So the bill does say, okay, it is automatically unfair if you're dismissed for refusing to agree to this variation of contract. But there's what we have called here a limited exception, and people can debate in the room whether they think it is limited, where the employer is in various forms of financial trouble and some allowances are made for this. So one of the other areas we're going to be thinking about is, how do we make this as tough as are for the employers when they actually, if they do go down this route. The consultation published today, and I'll go on to say a bit more about that, talks about strengthening those protections. But again, if we want employers to actually comply with the law, then the incentive to do so has got to be significantly stronger than it is. Now, our changes to the collective redundancy provisions. So in smaller workplaces, to ensure that workers have to be consulted. And this is specifically relating to the P&O case, where the owners of the ship claimed that because it was not, because it wasn't registered in the UK, basically, they didn't have to comply with UK law. It's basically removing that loophole. There are tougher rules on outsourcing and on pay gap reporting. These are just linked together. They're not thematically linked. They just both fitted on my slide in the right place. So don't attempt to draw a theme here, but there is outsourcing, the practice where people remove people often from the public sector, transfer them to the private sector, often as a cost-saving measure. It's been one of the ways in which workers' terms and conditions have been driven down significantly over the past probably more than a decade, 2 decades. Also one of the ways in which you see structural racism often embedded in labour markets. You will see the cleaners or the security guards are on lower terms and conditions than people who might work in the public sector, and often racialised and minoritised workplaces. So the bill goes a little bit of the way, a very little bit, into delivering what the government described as the biggest wave of insourcing in a generation. And strengthens the 2-tier code, which is a code meant to ensure that people do not have 2 tiers of workplace protections. There's still a long way to go around that. And then the government have committed to do 3 types of pay gap reporting. This bill requires employers to actually publish an action plan around gender pay gap reporting, which is already a requirement. A later bill is due to introduce a requirement to publish ethnicity and disability pay gap reporting. There are 2 new sectoral bodies. I'm going to speed up a bit so that I get through the whole talk and allow people to have some questions introduced in this. One in social care and one reinstating what's called the School Support Staff Negotiating Body. This is allowing employers, public sector employers in most cases, and unions to come together to set minimum terms and conditions both in social care, which is new, and for school staff, which was previous arrangement that was in place. Useful to debate whether we think this is a step forward in introducing sectoral bargaining. We think it is, but I think an issue that people might want to comment on when we get into questions. There are stronger trade union rights, whether they are strong enough, again, an issue for debate, but there are new provisions around enabling trade union access to workplaces. They have put into the bill a set of provisions which allow for an agreement between a union and an employer around the union's access to workplaces. It's to be regulated by a body called the CAC, which is the Central Arbitration Committee, which currently regulates union recognition deals. I think that commitment to enable unions to access workplaces is a really important one. And again, consultation published today sets out how we might strengthen that. And I think, having read the bill so far, that is certainly an area for focus. The bill also should make it easier to be recognised as to have trade union recognition in the workplace. So it scraps the current requirement to have 10% of members of a bargaining unit, a workplace basically, to be members of the trade union before you can apply for trade union recognition, but it hasn't yet set out what that number is going to be. The bill says it's between 2 and 10, but again, consultation on that. The bill repeals most parts of the 2016 Trade Union Act, which significantly put new hurdles on the right to strike in the UK. And in fact, when I joined the TUC, it had just been passed, basically. A lot of concessions won by the TUC during that period, but a real attempt by the last Conservative government to basically throw grit in the wheels of workers trying to organise and take industrial action to defend their jobs, pay and conditions. So there are a large number of hurdles which were introduced by that Act in 2016, which this bill basically repeals. New provisions for trade unions, statutory duties for equality reps, strengthen protections against blacklisting, further protections against detriment for taking industrial action. So what your employer can do if you have taken industrial action. And I nearly forgot to put the minimum services legislation on the slide, despite having spent the last 2 years campaigning on this. So the most recent version of the Conservative government tried to introduce these provisions around minimum service levels. Again, another attempt to restrict the right to strike in the UK. It is pretty satisfying that these provisions will never have been used. They were passed in 2023. We spent a lot of time campaigning against them. I think even public sector employers were saying these were deeply ineffective. And luckily, we have had this bill in place before a single work notice. These provisions would have allowed employers to compel someone to break their own strike through a mechanism called a work notice. No work notice has been issued, and these provisions are set to be repealed in full. So there is quite a lot more to come. This bill is already big, and the government has basically said that this agenda is going to get bigger. So today we had three consultations published. One on the rate of sick pay for those on low earnings, one on tackling 0 hours contracts when it comes to, or applying the 0 hours contracts provisions when it comes to agency workers, one on strengthening remedies against fire and rehire. And then we have this big and potentially significant consultation document, which I don't think anyone has fully had a chance to absorb yet, but basically sets out some potential to strengthen the provisions around trade unions gaining recognition in workplaces, to simplify industrial action ballots and the requirements on trade unions to provide information, to update the law on repudiation and prior call, which are areas where trade unions are inhibited, other areas where basically employers will try to trip up unions who are taking industrial action. Strengthen the access provisions, and I've put in this slightly inelegant question which says, are there any wider modernising reforms relating to trade union legislation that you would like to see brought forward by the government? If yes, please state these and why. Basically, because I kind of think it's amazing that we've got this question which basically says, how can we strengthen trade union rights? We don't yet have the answer from the government saying, oh yes, of course we will now implement the TUC's recommendations. But the fact that we've got this question is a big opportunity for all of us who care about collective rights, I think, to really make the case for why trade unions are important. So that was, oh, there is more. I'm not going to do this. These are the further consultations that the government has committed to, and they published a document which is really worth reading, partly because it summarises the bill, which is called Next Steps in Making Work Pay, which basically sets out things which were in their pre-election document, which have not yet been delivered in the bill, and what they say they are going to do as a consequence of this. So as I said, it's a pretty massive agenda. So I just wanted to take this time to reflect a little bit on kind of whatever you think about the provisions in the bill, whether you think they're strong enough, whether you think they go far enough, how you think they're drafted, you know, do they actually deliver the change we need to see for the workers I was talking about in the beginning of this? I think it is worth thinking about, how did we get to a stage where a new Labour government is introducing what is, at any rate, a pretty broad package of employment reforms? And this chart is kind of saying, well, you could just say it is politics, basically. So this is going back to that comparison between the UK and the OECD on its labour laws and the gap between them. And you can see some pretty clear political trends. We have changes of government and our labour laws get weaker. We have, you know, a slight uptick following a change of government around the 90s. And then we see kind of basically nothing happening and then starting to tick down again under the last Conservative government. I tried to put a kind of arrow in saying, are we about to see that gap massively closed? But my PowerPoint skills were not good enough. And it's also probably a subject for debate. So maybe the answer to, okay, how have we had the significant shift is, well, we've had some political change, you know, maybe we think this is just what Labour governments do. But I think it is worth thinking about some of the other factors that got us here. And I think most people would probably agree that the set of changes we've had set out in this bill so far probably do go further, and they go further towards strengthening collective rights, or at least they repeal anti-trade union legislation, which hasn't happened for a while, than the set of changes we got in 1997. So part of that is lots of people in this room have done an awful lot of campaigning about this, and the types of impacts of insecure work on people's lives, I think, have become much more visible over the last decade. There have been more people in insecure work, so more people have understood what that means for their lives, and it's become more visible to kind of public debate, aided by quite a lot of work by quite a lot of people. I've highlighted just a few things here, some of the TUC's own work. We've been publishing an account of the number of people in insecure work since 2016 and working on these issues for long before that. There's a motion to our Congress called A New Deal for Workers from the Communication Workers Union. That's in 2016. So maybe some of the first use of that language, although many people would claim it. We saw lots of work by the IER. This isn't their original document, setting out a raft of changes, the Institute of Employment Rights, that is, that they thought we needed to see in the world of work. And then we had this green paper from Labour back in 2017. But I think it is kind of worth noticing that it was also becoming mainstream to talk about employment rights during this period. So the not much lamented Taylor Review, which the Theresa May government actually published, did say we need to put the quality of work at the centre of public debate. The TUC criticised it at the time for not going nearly far enough, but it showed that it was on the agenda. And even the last Tory government said they were going to have an employment bill. So I think this campaigning, obviously taken forward by a Labour government, mostly taken forward by people on the left of the political spectrum. But during this time, the quality of work as a subject of public debate, I think, was becoming significantly more central. I think during this period, and again, I think, you know, this is when you get into a kind of how does change happen? But I think it probably has helped the people who are pushing for this bill that there's been a massive change in the kind of economic, elite, sort of technocratic world in how they see trade unions and what they think of as important in terms of labour market regulation. So one of the quotes is from the OECD. The OECD in 1994 published a big report where it basically said, flexibilise your labour markets, remove labour market protections, otherwise you will face high unemployment. And that was very influential in guiding thinking for a long period. In 2018, they kind of recanted on that, basically, and said, oh, we've noticed that trade unions actually make a big difference in the world of work, that it is possible to have better quality of work and quantity of work and low unemployment, and kind of said we've got it wrong and changed their advice. The IMF, not always a friend to workers, has also been on, let's say, a journey and published research showing the links between declines in unionisation and inequality. And I think this quote, which is really too long to be on a slide, but this is from Angus Deaton, who is a Nobel Prize winning economist, basically saying, this is what everyone thought about unions. They were a nuisance, they interfere with personal efficiency, and I welcomed their slow demise. And now, sort of 20, 30 years later, I've realised I was completely wrong. You know, their decline, unions' decline is contributing to community destruction and to rising populism. And then, you know, coming up with this insight, which people who have been working for trade unions have always known, that the direction of technical change has always depended on who has the power to decide. And I've put that quote up in length just because I think it really shows that shift in kind of the elite consensus that has surrounded some of these changes taking place. And I think the change in that consensus has made it easier for a government to bring forward a bill that is broad at this time. Two more factors I thought worth noticing. So lawyers have been doing their job during this period and taking test cases, which have also shown the need for an upgrade or maybe just the enforcement of our current legal provisions. Again, you probably know about the Uber case where the Supreme Court ruled that these drivers were not self-employed, changing the way that Uber had to treat them. And I've just put the other picture up, which is Deliveroo concluding a deal with GMB trade union, whose building we are actually in, Nicola tells me, which is amazing, to kind of show that these legal cases are definitely 100% influencing employer behaviour here. And I think, again, when we're thinking about what's the background that's leading to us being able to have this wide set of changes, that this and other legal action is probably an important part of it. And then just the last factor I think is probably really important is the pandemic. Basically, I think we saw the visibility of what was sometimes called essential work, what was sometimes called frontline work, and of the people who are often subject to these terms and conditions in a way that should have been visible before to all of us, but too often wasn't. And I think maybe, you know, if we were looking back on this in 100 years' time, we would see that as one of the moments where kind of the consensus that we needed to change something here happened. So I've got a sort of claps don't pay the bills quote. The importance of sick pay, I think, really highlighted in the pandemic. And then this was a UCL lecture, which I thought had a really nice title, but, you know, essential yet exploited, basically. And I think the visibility of these many workers suffering these terms and conditions came to the fore a little bit more during that period. So what comes next? It is a big agenda. And I guess the first thing to say is there is a long way to go before the bill cut becomes law, and there will still be a lot of employer opposition. So just before I left, the government's published its impact assessment of the bill. It actually says this will transfer money to low-paid workers, it will have a negligible cost to businesses, and it will promote growth. But you will see that the narrative that the press want to write up is UK workers' rights reforms will cost businesses. And this is an area where we know there is going to be a lot of campaigning against this bill. And our job is to keep up the noise for why it is needed. That campaigning includes strengthening the bill. This is not a definitive list of areas where it needs to be strengthened, but it's some that our unions have already highlighted around access rights, around recognition, around 0 hours contracts, around the protection for unfair dismissal, simplifying the industrial action legislation, decent sick pay, widening sectoral bargaining perhaps, and I've put and more because this is by no means a definitive list, but one we could maybe discuss. I think this is my last slide, you'll be relieved to hear, but just 2 really important things I wanted to end with. So, you know, we all know that collective rights and power, that being able to negotiate your pay terms and conditions through a trade union are the best way to drive up pay and conditions at work. These new rights should enable the union movement to grow, but we have to take advantage of that. Our membership ticked up a tiny bit in the last year, but it's been declining for a long time. Initially to Angus Deaton's pleasure and now to his disappointment, but turning that graph around is basically what this bill is about. And there's much more than just passing the legislation to achieving that. And then I guess I think we need to start planning for what comes next. This is a big agenda, but it's certainly not going to cover everything that trade unions have ever wanted or that workers ever need. 2 things I thought maybe to put on the agenda, but there will be much more. Expanding that sectoral bargaining, but beyond social care. And then I think, you know, there's a big sort of missing bit of the bill when it comes to new technologies. The government's acknowledged that. It says it's going to have a consultation on new surveillance technologies and how we respond. But thinking about how we have the right protections in place to respond to a changing world of work is something that trade unions need to be doing right now. Stop there.
Thank you very much.
Thank you for having
Thank
me.
you all.
Thank you for
and
listening.
see you in the next event. Thanks.